first case of the morning is State v. Randle. Each party will have 15 minutes to present the argument. In this case, it's only you, Mr. Myers, so you may have all 15 minutes. If you want to rebut yourself, you can in your last 5 minutes, but that's up to you. The arguments are being recorded. Make sure when you present your argument again, make sure you stand behind the podium and you speak in a loud voice and introduce yourself before you start so we can adequately hear you on the recording. In this case, if you have any victims or minors or anyone, please make sure you refer to them by initials and not their full name, if you will. With that, the court has read your briefs, and I'm ready to proceed whenever you are.
Thank you. Good morning, Your Honor. Paul Meyer for the appellant, Rachelle and Randle. I'm really sorry that the state of Ohio and Mr. Raley are not with us this morning. Apparently they didn't feel the need to argue. I've always felt that oral argument is an important part of the appeal, so we definitely requested the opportunity. Since you've read the briefs, you know that I made certain assignments of error, but there's one assignment of error I did not make, and I never make this assignment of error, and that is ineffective assistance of counsel. And I've seen this very frequently presented as an assignment of error in criminal appeals. And rarely does the court find that type of assignment to be well taken. I know the court doesn't like to second guess the strategy and tactics of defense counsel, and I don't want to do that either. I used to be a prosecutor, and I know you need evidence to obtain a conviction. In this case, under appeal, there was some evidence produced. The actual evidence that supports the conviction, I think, I was looking at the definition of scintilla. It means a tiny trace, I think the most compelling bit of evidence that was adduced at trial from reading the transcript, I did not try the case, was the stipulated polygraph exam. I think that was very unfortunate, and obviously in hindsight, it was a very risky thing to do, but that did come in. Now, what was produced at the trial was the victim's testimony. The victim testified that he was being followed by a car. This actually happened about 4 years ago in July of 2020. On one summer evening, a car following him, he became concerned, a little suspicious, and then he heard gunfire and saw muzzle flashes. He didn't actually see more than that. He heard some gunfire, as his testimony was. He saw some flashes. He calls 911. The very first thing he says is, "My brother shot me." His brother is a felon whose initials are DR. "My brother shot me." Now, that's in the nature of an excited utterance. And the laws of evidence, we give a lot of credence to excited utterances and things that speak for themselves.
On that same 911 call,
Yes.
is he correct to say that the defendant was the person who shot and his brother was the driver at that point?
On the 911 call, I believe he said that my brother shot me. That would be DR. In his testimony at trial, he said he saw the car being driven by DR, the brother. Then he heard some gunfire and saw some muzzle flashes. That was his testimony at trial. He also testified there had been previous bad blood between him and his brother DR. Previously, the brother apparently shot his tires, the victim's tires. He had also posted a threatening post on Facebook. In fact, there was one photo of the brother holding a gun, a semi-automatic weapon, and some of the shell casings that were found at the scene of the shooting in July of 2020 actually could have come from such a weapon. At least that was the expert testimony of one of the police officers. So the victim had a problem, and no problem. His testimony was he hardly knew the appellant. There was no prior animosity of any kind. So our position is the testimony was very inconsistent, very spotty. My brother shot me. So the police, within 10 minutes, 10 to 15 minutes of the shooting, they go to the residence of where the brother lives, looking for the brother, DR. The appellant comes to the door in her bathrobe, her night clothes, and they talk to her. They don't do any gun testing, any gun residue testing or anything. They never did test the shell casings that were found for fingerprints, DNA, or any other type of forensic tests. So we go to trial. She's charged, and the evidence is this inconsistent testimony plus this polygraph exam, the stipulated polygraph exam. Now, unfortunately, and there's a reason why polygraphs are inadmissible. We all know this, unless you stipulate, which is a risky thing to do. It was done in this case. The appellant testified she had some serious health issues. Her father died 2 days before the polygraph test. So, and they hadn't even made funeral arrangements yet at the time of the test. The examiner felt that she wasn't being truthful. She asked to take another test, and he refused. So we have that stipulated polygraph in front of the jury. So our position is the Rule 29 motions should have been granted. 2 of them made during the course of the trial. You feel like the state of life.
Is your position that
Yes, sir.
because of the nature of polygraphs, we should not find that have sufficient weight in this case?
Well, I think the testimony around the polygraph exam, which was the appellant who testified about her health issues, her state of mind at the time she took the exam, her father having died 2 days prior, still making funeral arrangements. I think she indicated that she was very upset and mental, emotional distress, and then she asked to take the retest and didn't get that opportunity. So that's she was supposed to take the test at one earlier time, and she wasn't medically qualified, and the examiner had her come back. And so when she came back, this is the circumstances that prevailed when she took the test, and then that was the end of it. So again, that was I think a crippling bit of evidence in her case. At least that was my impression looking through things. But again, we feel like she's languishing at the Ohio Department of Rehabilitation and Correction right now, convicted of felonious assault with this firearm spec, the drive-by shooting spec, and the evidence that was actually used was, aside from the polygraph, is inconsistent. The victim says, "My brother shot me." The police go look for the brother. They end up encountering the appellant. She's the one that's charged. She's never tested for gunshot residue. At one point, a police officer puts his hand on the hood of the car, and it seems warm to the touch. Again, there was testimony that the appellant and her partner had gone out to dinner earlier that evening. They had driven up to, I think, the Steele's Corner Road area, went to a restaurant up there, came back, and the car was parked in the driveway. Now, I drove down to the courthouse today. My car's parked in the Summit County parking deck. I'll bet if you put your hand on my car, on the hood of the car, it'll still be warm to the touch. I mean, I don't believe that that's convincing in any way that that car was used in a drive-by shooting that night. So we feel like there was insufficient evidence to support the conviction. We feel like the verdict was against the manifest weight of the evidence, and we feel like the trial court should have granted the criminal rule 29 motions for acquittal. So that's pretty much our position.
Thank you.
Any questions?
No, sir, thank you for your presentation today. On behalf of the court, the court will take the matter under advisement, issue a decision in due course. When that decision is reached, the court will mail a copy of it to you, and it will also be on the High Supreme Court's website.
Thank you very much.
Thank you.
Have a good day.